Welcome to all. I hope my voice is very clear to everyone. In the comments, you people please mention that is I am audible to all. Very good afternoon, Meta. Very good afternoon, Malika. Okay, very good, very good. As far as we are here with respect to the rapid revision round on the CRPC, and we will be discussing section 1 till section number 199 of the Code of Criminal Procedure. But apart from that, with respect to the CRPC, I would firstly like to mention you people that with respect to the daily judicial services, what kind of questions are coming in the DGS exam with respect to the Code of Criminal Procedure, and for that I will be sharing a file with you. Just give me 1 second. These are the kind of questions which are there in daily judicial services, primarily with respect to the trends which the DGS is taking up. With regard to the CRPC, we are looking that the questions are more Bare Act based questions. As you people can see, only the Bare Act based provisions are there. Conceptual questions are not, a lot of questions are not there. To the maximum from 200 maximum questions, 20 questions will be there from the Code of Criminal Procedure. You should be very much competent enough to understand the Bare Act, and once the Bare Act is very clear to everyone, you will be able to handle all the 20 questions which are there in your exam. Okay, so I think we should start with the session. We should start with the session, and let us come to the quick rapid revision round, and I will be taking up the things with respect to the Bare Act approach, as well as the recent scenario case laws which are being passed by the Honorable Supreme Court, and other things which are important with respect to your exams. So we are taking up it one by one. Okay, very good afternoon to everyone. Very good afternoon. Chaliye, so let us start. Look, as far as the CRPC is concerned, the basic things which you people have to understand, that CRPC is under which area of the constitution it is there. So you people must write down in your barracks itself that CRPC is in the concurrent list of the constitution 7th schedule, and entry number 2 of the concurrent list is there, which is referring that on the Code of Criminal Procedure, the Parliament as well as the state legislatures can make the law. With respect to that, as you people know that okay, the state amendments are there with respect to the CRPC, so that state amendments are usually there only because it is in the concurrent list. Now the next point is that how this CRPC 1974 is there. So earlier in 1852, there was a old law, that is Criminal Procedure Supreme Court Act, which was repealed in 1865, that is by the High Court Criminal Procedure Act. Thereafter, again, a new law was enacted. There was CRPC 1882. Then thereafter, a new CRPC 1898, and after that, the 41st Law Commission has made a report that okay, the new CRPC is required, and thereafter the new enactment is there in 1974. Now you people must have to understand that what is the reason behind this new law that was there in 1974. So in the 41st Law Commission report, these are the things which are required to be incorporated in the CRPC, and the basic things that were incorporated were, as you people can see, like fair trial. So fair trial was one of the very important thing which was required to be introduced in the CRPC. Thereafter, avoid delay in the investigation. Investigation should be time bound. Thereafter, procedure should not be complicated. There should be fair deal to the poorer sections of society. Separation of judiciary with executive, committal proceedings to be abolished, summons procedures to be abolished. There is no revision against the interlocutory orders. Cost for adjournment is there now. In petty cases, plead guilty by post option is available. For errors, omissions, and irregularities, no order of retrial can be there. So these are the basic things which were required to be incorporated in the code of criminal procedure, and accordingly now the CRPC which we read, in that CRPC all of these things are implicit. Similarly, the legal aid to the indigent person, payment of compensation by the accused to the victim, issue of commissions for the examination of prosecution witnesses, and prosecution will bear the burden of that. So all of these things are primarily recommended by the 41st Law Commission, and thereafter in the 1974 when the CRPC was enacted, we got everything in the CRPC. Now, what kind of questions can be there in your prelims exam with respect to the code of criminal procedure? You people must have to understand this law is exhaustive in nature, because in the preamble of this law the word consolidated is written. So whenever in any law you get the word consolidated, it means that this law is exhaustive with respect to the things it is carrying. Similarly, the next point which people have to understand, that on which particular date the president has given assent to this law, that is of 25th of January 1974. The assent of the president is there to the CRPC, but it came into force on 1st of April 1974. In your barracks itself, these things are written. You people must ensure that these things are important with your prelims point of view. But with respect to the territorial extension of the CRPC, as earlier prior to 2019, before the reorganization of J&K, it was only applicable to the India apart from J&K, excluding J&K. But now there is a reorganization of the Jammu and Kashmir, and now CRPC is applicable to the whole of India. But a very important point, that the provisions of CRPC does not applies to the state of Nagaland as well as to the tribal areas. So this is very important thing. But there are certain chapters in the CRPC which usually applies to the state of Nagaland as well as to the tribal areas also. And what those chapters are? These chapters are chapter number 8, chapter number 10, and chapter number 11 of the CRPC. These three chapters of Code of Criminal Procedure are usually applicable in the state of Nagaland as well as in the tribal areas also. So you people must mark it, that these chapters of CRPC will be applicable to state of Nagaland as well as to the tribal areas. Because from this point, a lot of times the MCQ comes in different state judiciary exams, and definitely in the Delhi judiciary, because the exam is with respect to the CRPC, it is more oriented towards the Bare Act interpretation, Bare Act only. So you just mark it down in your concerned Bare Act, that chapter number 8, chapter number 10, and chapter number 11. These chapters of CRPC will be applicable to the states of Nagaland as well as to the tribal areas, but the other part of the CRPC will not be applicable in these particular areas. Now coming to the definition part, now there are multiple definitions given, but which definitions are required to be taken up, which are important, I had highlighted over here. As in section number 2 of the CRPC, clause number A, the definition of bailable offense is mentioned, like any offense which according to the first schedule is mentioned as a bailable offense, it is considered to be bailable, and the other offenses will be considered to be non-bailable offenses. So this is a very important thing. Only the direct question with respect to the definition can be there, like where the bailable offense is defined in CRPC. It is section 2, clause number 8. Next, what is charge? So charge means a head of charge, or charge contains more heads than one. So whenever the trial in a criminal matter proceeds, the charge is required to be framed. Section number 211 of the CRPC will be telling you that what are the contents of the charge, and whenever the charge is to be framed, on the basis of that charge only, the complete criminal trial is to be based upon. So it is very important to understand that what the charge is. So charge means the name of the section, number of the section which is there given in the penal law. Like for example, IPC section 302. So 302 is the charge frame against the accused person. The next point is what is the cognizable offense. So cognizable offenses and non-cognizable offenses, this criteria is being given in the schedule of the CRPC. Schedule will tell you which offenses are cognizable, which offenses are non-cognizable. But the basic difference which is being there, that in the cognizable offenses a person can be arrested without warrant. A person can be arrested without warrant, and in the non-cognizable cases, section number 2 clause number L will be there, and it says that in such cases the arrest cannot be there without warrant. Now the next definition which is important for you people, that is the definition of complaint. This definition is important because multiple things are there. Whenever any person makes a complaint either orally or in writing, first point, orally or in writing to a magistrate, and the purpose of raising the complaint is that any offense is being committed by someone, that offense can be a cognizable offense, it can be a non-cognizable offense. Against which person you are raising it, whether you know that person or that person is unknown, doesn't matter. So the complaint means an allegation made orally or in writing to the magistrate, and that some person, whether known or unknown, has committed an offense. And what kind of offense? It may be cognizable, it may be non-cognizable offense. But complaint is something which is different from the police report, and that is why, for the clarification, it is mentioned over here that complaint and police report both are very different. Both are very different. Now, apart from this, there is a kind of a situation where initially the investigation has been proceeded as it is a cognizable offense, like the FIR is lodged and thereafter the investigation is started without the permission of the magistrate. But subsequently, when the charge sheet is filed, it is disclosed that the offense is of a non-cognizable character. So the moment after the investigation it appears that the offense is non-cognizable, the police officer, whosoever is filing that police report, will be considered to be a complainant, and the police report will be considered to be a complaint filed before the court. So this point is very important, that whenever after the investigation completes and you mention to the court that sir, it is a non-cognizable offense, so the moment you are doing so, your police report will be considered to be a complaint, and the person whosoever is moving that complaint police report before the court of law, that police officer will be called to be the complainant. This thing is reiterated by the Supreme Court in this particular judgment, that is Muhammad Yusuf versus Afaq Jahan. The judgment is of 2006 Supreme Court, and a very, very important judgment. This judgment is very important with respect to this point, that how the complaint can be filed, and other things are also very important in this particular judgment. Now, the next definition which is important for you, that is the definition of inquiry, that is in section number 2, clause number G. Most of the times directly the question comes that in which provision of CRPC inquiry is defined. So section 2 clause number G should be in your knowledge. Inquiry means something which is not a trial. Something which is not a trial. An inquiry is conducted by the magistrate or by the court. Now the question comes that when the inquiry will start. So inquiry usually starts the moment the court takes the cognizance, until the charge framing, whatever the proceedings are there before the court of law, everything comes under the inquiry portion. The next definition, which is important, that is the definition of investigation, section number 2, clause number H. Investigation, primarily it will be done by the police officers, and the purpose of investigation is to collect the evidences. Okay. The next thing is, what is the judicial proceeding? Judicial proceeding. So with respect to the judicial proceeding, any proceeding whereby the evidences are there which are legally taken on oath. Evidences are there which are legally taken on oath. If such kind of proceedings are taken up, then such proceeding will be called to be the judicial proceedings. Now, the next definition which is important for you people, that is the definition of non-cognizable offense. As I stated, in the non-cognizable offenses, police officer has no authority to arrest without warrant. Next one is the definition of offense. Offense, the definition given in section number 2, clause number N, is very wider, and it is covering every punishable act under any law. As it is written over here, that it means any act or omission punishable under any law for a time being in force. Under any law for a time being in force, and it includes the complaint made under Section 20 of the Cattle Trespass Act. So these are the basic things you people have to understand. And as you people have already gone through with the Bear Act, so I hope you people have made and jotted down the bullets points on these important definitions. Now the next definition which will be important for you people, that is public prosecutor. Public prosecutor is a person whosoever is appointed under section number 24 of the Code of Criminal Procedure, and any person who is acting under the directions of the public prosecutor, that person is also deemed to be a public prosecutor as per section number 2 clause number U के जिस व्यक्ति का अपॉइंटमेंट हुआ है सेक्शन 24 के अंदर वो भी पब्लिक प्रोसिक्यूटर, और पब्लिक प्रोसिक्यूटर ने अगर किसी को डायरेक्शंस दी हैं काम करने के लिए, so that person will also be acting as a public prosecutor as per the definition given. Next thing, that is what are the summons case and what are the warrant cases. Any offense for which the punishment is less than 2 years, that offense will be considered to be a summons case. And any offense for which the punishment is the death or life imprisonment or imprisonment for a term exceeding 2 years will be called to be the warrant case. So these are the basic things with respect to that what is the difference between summons case and the warrant case. The basic difference lies on the point that offenses for which the punishment is more than 2 years or life imprisonment or death, etc., that offense will be called to be a warrant case. That case will be called to be a warrant case, and the other category of offenses that is less than 2 years will fall under the summons case. So these are the definitions which I had highlighted you people. You just mark on your concerned Bear Act. From these definitions, definitely the questions usually comes in the exams. Now the next point which you people have to understand is that with respect to the Code of Criminal Procedure, one thing is very clear that there are two kind of offenses we have. One, offenses which are being covered under the Indian Penal Code, and there are some other special laws in which some specific category of offenses are being there. Now, if the offense is under IPC, the procedure will be taken up whatever is given in the CRPC. But with respect to the special laws, if the procedure is there in the special law, like for example, there is a law that is Prevention of Money Laundering Act. So if Prevention of Money Laundering Act it is a special law, and the procedure with respect to the working of this special law is also mentioned in the law itself, that is in the Money Laundering Act itself, the working of the Prevention of Money Laundering Act is given, then it is not required to see the CRPC. But wherever the special law is silent upon any point, wherever it is silent, you will follow the parent law, and the parent law is the CRPC. The procedure will be followed from the CRPC itself. So this is very important with respect to how the procedures are to be taken up. The next thing which you people have to understand, the point which I related right now, that is in section number 4 of the Code of Criminal Procedure, it is mentioned over here. And the next thing is in section number 6, that what are the classes of the courts. So with respect to the classes of the courts, as per section 6, there are 4 classes mentioned, that is Court of Sessions, Judicial Magistrates of first class, and in the metropolitan area there will be the metropolitan magistrates, there will be judicial magistrates of second class, and there will be the executive magistrate. Now these are the 4 classes of the criminal courts which are there as per section number 6 of the Code of Criminal Procedure, and these 4 classes of courts are beside the High Court. So High Court is always there, but apart from that, these courts are also there, that is Court of Session, JM1C, that is Judicial Magistrate first class, metropolitan magistrates in the metropolitan cities, and the Judicial Magistrate second class, and executive magistrates. Now, the next thing that is important for you people, and in the 2019 from section 9 itself, there was a question in the Delhi Judicial Services. So firstly, let me tell you that what was the question. This was the question that court of session shall ordinarily hold its sitting as per section 9 of the CRPC at which place? As per section 9 आप अगर court of session जो है उसको कहीं पे sitting hold करनी है तो कहाँ पे करेंगे? So this question is direct question with reference to section number 9 of the CRPC. So section 9 is again very important because earlier 2-3 times from section 9 the questions are there. So you people just see what are the various important pointers over here I had highlighted over here. That is, the state government will establish the court of session. This is first point, that who will establish the court of session? It is only the state government. High court will not establish the court of session, but the appointments will be done by the high court. Appointments will be done by the high court. And in section 9 itself it is very clear, in section 9 it is very clear that high court may also appoint additional session judges, assistant session judges to exercise the jurisdiction in the court of sessions. So it is the high court who is going to appoint the ADJs, that is the additional session and assistant session judges, with respect to the working of the courts. But you people just see the last clause, that is clause number 6 of this particular section, that is section number 9. It is saying that the court of session shall ordinarily hold its sitting at such place or places as the high court may by notification specify. So who is going to specify that where the court of session shall be holding its sitting? So it will be decided by the high court. But if in a particular case the court of session is of the opinion that it will tend to a general convenience of the parties and witnesses to hold its sitting at any other place in the sessions division, it may with the consent of the prosecution and the accused. It may with the consent of the prosecution and the accused. Mark कर लीजिए, underline करेंगे. With the consent of the prosecution and the accused, sit at that place for the disposal of the case and for the examination of the witnesses or witnesses therein. So this is important, and this is from where the question is there in Delhi Judicial Services 2019 exam, that where the court of session is going to ordinarily hold the sitting. So place wherever the high court by notification has ordered, and if it is for the general convenience of the parties and of the witnesses, the court of session can be holded on in the sessions division with the consent of the prosecution and of the accused. So these kind of questions can be there, as you people can see in 2019 itself this question was there. तो ऐसे सवालों का ध्यान रखना है. बेरेक्ट पे जितना ज्यादा बेरेक्ट के साथ दोस्ती करोगे उतने ज्यादा आंसर्स आपके अच्छे होंगे. Now apart from this, onward section number 9 till section number 23, multiple kinds of courts like chief judicial magistrate first class, judicial magistrate second class, special judicial magistrates, etc. are being mentioned. So I will give you a trick that how you will be able to understand in which provision which judicial officer is specified. Okay, so I'm writing over here. You people can, if you people have the notebooks, you can just jot it down that there is a judicial magistrates for metropolitan magistrates and for the executive magistrates. What provisions will be there with respect to the CRPC? So section number 11, section number 12, section number 13, and section number 15. Section number 15. These provisions will be with respect to the judicial magistrates. With respect to the metropolitan magistrate, it will be section number 16, section number 17, section number 18, and section number 19. Section number 19. And with respect to the executive magistrates, it will be section number 20, 21, and 23. 20, 21, and 23. Now, how this particular trick is going to tell you that how you will be able to recall the things. So in section number 11, it is talking about judicial magistrate. So same if it is a metro city, so there will be the metropolitan magistrate given in section number 16. Okay, and for the executive magistrate's appointment, it is section number 20. ठीक है, बहुत जल्दी से आपको ये चीजें याद हो जाएंगी. दूसरा, with respect to chief judicial magistrate and with respect to additional chief judicial magistrate. CJM and ACJM. Section number 12 is with respect to this, and if it is a metro city, then there will be the chief metropolitan magistrate and chief additional chief metropolitan magistrate. So it will be there in section number 17. So you people just check it out in your concerned bare acts. Just see, like in section number 11 you are getting, okay, court of judicial magistrate is there. Thereafter in section number 12 it is talking about chief judicial magistrate and additional chief judicial magistrates will be there. In section number 13 it will be talking about special judicial magistrates. So you people can mention over here, it is section number 13 which is talking about special judicial magistrates. So as it is there in section number 13, and thereafter section 14 is talking about the local jurisdiction of the magistrate. This section is not that much important, but you may write it down. Section 14 अलग से इसको लिख लेंगे, that is it is talking about the local jurisdiction of the magistrates, local jurisdiction. Similarly from 16, 17, 18, 19 what you are getting, just see the bare act, just see the bare act. In section number 16 it is chief metropolitan magistrate. In section number 17 it is special metropolitan magistrates. Okay, ये थोड़ा सा यहाँ पे गड़बड़ हुआ है, just give me 1 second. I think the bare act there is no problem. Yes. So in section number 16 it is section number 16 your concerned bare act, it will be the metropolitan magistrate. In section 17 it is chief metropolitan magistrate, and in section number 18 it is special metropolitan magistrates. Okay, so that is why this chart will be beneficial for you. That is section number 16 for metropolitan magistrates, 17 will be for chief metropolitan magistrates, and section number 18 will be for special metropolitan magistrate. So this is a trick by which you will be getting to know that, okay, under which provision which magistrate is being referred. So 11, 12, 13 for judicial magistrates, 16, 17, 18 for metropolitan magistrates. And if you people see onward section number 21, so onward section 20 you can see 19, 20 you will be getting in your concerned bare acts. In your concerned bare act, just take it out, section number 20. It is talking about executive magistrates. In section number 21, it will be talking about special executive magistrates. Special executive magistrates. So these are the things which people have to understand, that okay, in which provision, which thing is being mentioned. So apart from these sections, like onward section number 10 till section number 23, a lot of questions will not be there, but yes, you people just have the broader idea that okay, in which provision which magistrate is being referred. And the other thing which is important for you people, that is who is going to go for the appointment of these magistrates. So as it is written that the High Court shall, in relation to the metropolitan area, will appoint a metropolitan magistrate. Similarly, with respect to the judicial magistrates, the same kind of provisions you will be getting. So इसका थोड़ा सा आपको ध्यान रखना पड़ेगा that whosoever is going to appoint, आपको उसका ध्यान रखना है. Like in section number 12, you will be getting that in every district, the High Court shall appoint judicial magistrate of first class to be the chief judicial magistrate. So who is going to appoint? That is the High Court is going to appoint. So यहाँ से सवाल आपका जो है ये बनता है. Now, apart from this, the next important area for your prelims point of view, that is section number 24. Just take it out. Section number 24. That is with respect to the public prosecutors. And in section 24, it is saying that for every High Court, central government or the state government, after the consultation with the High Court, may appoint a public prosecutor, and there can be more than one public prosecutors, which called to be that additional public prosecutors. Okay, so who is appointing? That is the government. That is the for every High Court, after the consultation with the High Court, the central government or the state governments are appointing these prosecutors. But from where the question comes? The question comes that if there is not a regular cadre of the selection for the assistant public prosecutors or public prosecutors, then how the things will be settled? So it is stating in clause number 4, that district magistrate shall, in consultation with the session judge, just underline this point in your Bayer Act, just underline this, that district magistrate shall, in consultation with the session judge, will prepare a panel of the names which is, in their opinion, are fit to be appointed as a public prosecutor or additional public prosecutors for the district. So question comes that who is going to prepare a panel? So district magistrate shall consult the session judge. District magistrate shall consult the session judge. Thereafter, the panel will be prepared, and from that panel, the public prosecutors will be selected. But if in a particular state there is a regular cadre for the appointment of the prosecutors, then the regular cadre will be followed. So it is stated that in clause number 6, you see clause number 6, that notwithstanding anything contained in clause 5, where in a state there exists a regular cadre of the prosecuting officers, the state shall appoint public prosecutor and additional public prosecutor only among the persons constituting such cadre. So, if, as you people know, that in different states, the exams are there for assistant district attorneys or assistant law officers, etc. If there is a regular cadre for the appointment of the prosecutors or additional public prosecutors, then that cadre is to be followed up. But if there is no such cadre, who is going to prepare a panel? That is district magistrate along with the session judge. So these are the basic things you people have to understand with respect to section number 24. Now section number 25, talking about the assistant public prosecutors. Assistant public prosecutors, 2-3 questions are there from this particular section. Number one, that who is going to appoint the assistant public prosecutor? So if it is a state government and the matters are related to the state government will appoint. But if the matters are related to the central government, like for example any central legislation is there and central government want to get some assistant public prosecutor to be appointed, then central government will appoint such persons. So it depends that what kind of case is there before the court of law. Now another question comes that can a police officer be also appointed as assistant public prosecutor? क्या किसी पुलिस वाले को APP बनाया जा सकता है या नहीं? Generally the answer is no. But where no assistant public prosecutor is available, then in that case district magistrate, underline करेंगे, स्टार लगाएंगे, district magistrate may appoint an assistant a person to be assistant public prosecutor. But if a police officer is required to be appointed, that police officer cannot be appointed if he has taken a part in the investigation, and number two, he should not be below the rank of the inspector. So what is the journal rule? The journal rule is that the police officer should not be appointed as APPs, but there is a saving clause given in subsection 3 of this provision, which is stating that if there is no APP available, no assistant public prosecutor is available, then in that case we can appoint some other person. And generally, because the police officers are well acquainted with the law, they can be appointed. But no police officer will be appointed if he has taken participation in the investigation proceedings of that particular case, and the person should not be below the rank of the इंस्पेक्टर. सो ये दोनों चीजें जो है आपको ध्यान में रखनी है. इंस्पेक्टर से रैंक के नीचे का व्यक्ति कभी भी एपीपी अपॉइंट नहीं किया जाएगा. Now, what is the basic minimum eligibility criteria for being selecting as a public prosecutor or assistant public prosecutor, as it is specified in section number 25, capital A. Just see that who will be the director of the prosecution, who will be the deputy director of the prosecution, what should be their experience. So it is saying that the person whosoever will be appointed as a director of the prosecution, the person must be in practice as an advocate from last 10 years. At least he should be having a standing experience of 10 years. And if a person is to be appointed as a additional public prosecutor or special public prosecutor, etc., then in that case is also the minimum eligibilities are fixed. Minimum eligibilities are fixed. You people just see in the upcoming provisions that what is the minimum eligibility for such persons. Just see clause number 8 of this provision. Clause number 8. In your concerned variants, you may just mark it. It is in section number, I think, 25 itself, everything is specified. In section 25. Section 25, it is specified that what will be the practice experience required for public prosecutors and assistant public prosecutors. For public prosecutors, the person should be an advocate for at least 7 years period. At least 7 years period, it is specified over here. And if any person whosoever is to be appointed as a special public prosecutor, for that person, the experience as an advocate is should be minimum 10 years. Should be minimum 10 years. So it is important. It is there in section number 24 itself. With respect to the public prosecutors, it is there in section number 24 itself. Okay. Now, apart from this, section number 26, you people take out. Section number 26. Now, in section 26, the question comes that which of the courts will be having the concurrent jurisdiction? Which of the courts will be having concurrent jurisdiction? So, if any offense is there which is punishable under Indian Penal Code, that offense is to be tried by the court, High Court, Court of Sessions, and the court specified in the first schedule of the CRPC. These courts are having the concurrent jurisdiction. Concurrent jurisdiction means generally the court which is specified in the last column of the schedule specified in the CRPC, that court will take up the matter. But apart from that, the High Court and Court of Sessions will also be having the concurrent jurisdiction to entertain such matters, because concurrent jurisdictions are required. Reason being, there are certain provisions in the CRPC itself, like section number 408 is there, section number 407 is there, which empowers the High Court or the Court of Session to take up the matter themselves, to try the matter themselves. Section number 323 is there. Such provisions are basically enacted so that if the matter is to be tried by some other court, but the Court of Session is taking up the matter, it is possible. But how it is possible? Different provisions are there in the CRPC. If you people have gone through with these conceptual studies, I hope you are clear on that, like section 407, 408, 323, 325, etc. All these provisions will tell you that how the concurrent jurisdiction of the court is to be taken up. But with respect to the multiple choice question, you should be very much clear that if any offense is there under IPC, High Court, and the Court of Session, will be having a concurrent jurisdiction along with the court which is specified in the first schedule of the CRPC. But if any offense is there which is committed under some other law, any offense under some other law, then in that case, what is the process? The process is that if the courts are specified in that particular law, that court will take up the matter. But if there is no court specified, then CRPC will take its charge. CRPC schedule, last column, last part, that is part number B, will be telling that which court will be trying that matter, and High Court will be having the concurrent jurisdiction. So as it is stated, any offense under any other law shall, when the court is mentioned in this behalf in the law, be tried by such court. It means when there is a special law has mentioned a particular court, the trial will be taken up by that court only. But if there is no court mentioned in the special law, the case may be tried by the High Court or any other court as specified in the first schedule to be triable. So in the first schedule, part number B, that will be the last page of the schedule, which will be telling you that which court will be having the jurisdiction to try the matter if the offense is under some other law. Okay. Now, after this, section number 27 is there, which is important for you guys. That is, if any offense is committed by a person whose age is below 16 years, that is, juvenile has committed an offense, and the offense is not punishable with death or imprisonment for life. Offense is not punishable with death or imprisonment for life. Then in such cases, chief judicial magistrate will be having the competency to try the case. But if in the special law, like we have Juvenile Justice Act or other law, if in the special law any special court is created, then that special court will take the charge with respect to the trial of a particular offense. Okay. Now, coming to the next portion, I want to ask you people in the comment box, you people just mention me that if the Court of Session passes the death sentence, under which provision of CRPC the death sentence will be submitted to the High Court for confirmation. Yes, you people will tell me that under which provision the, the confirmation of death sentence is to be submitted to the High Court. Yes, everyone. Shaktija, Medha, Akash, Tanishka, those who are there. I hope you should be aware of this provision. Yes or no? Very good. So Manisha has given me the answer. That is section number 366 of the CRPC. Look, as with respect to the powers of the courts, High Court, Court of Session, or the other magistrates court like CJM and Judicial Magistrate First Class and Second Class, section number 28 and 29 are the relevant provisions. But whenever the High Court is required to pass any sentence, there is no restriction on that. High Court can go to any extent, even to the death sentence also. But whenever the session judge or the additional session judge has passed any sentence, they can go for any sentence. But if any death sentence is passed, then that death sentence is subject to the confirmation by the High Court. Confirmation by the High Court. And the submission is to be done under section number 366 of the CRPC. Submission will be done to the High Court as per 366. And under section 368, the High Court may confirm the death sentence, and thereafter the death warrants will be issued, and then only the person will be hanged till death. तो एक पूरा process है 366 और 368 के अंदर उसको follow किया जाता है. But apart from the death sentence, session judge has the power to pass any other punishment. With respect to the assistant session judges, what is the maximum punishment the assistant session judge can give? Yes, everyone. The maximum punishment assistant session judge can give is the 10 years period. This is the maximum punishment which the assistant session judge is competent to give to the offender, to the convicted person. Now the next point is what are the powers of the chief judicial magistrate first class, as well as the judicial magistrate second class. Judicial magistrate second class. Now what are those powers? With respect to the chief judicial magistrate, the maximum imprisonment which can be inflicted by the CGM is 7 years. Beyond 7 years, he cannot go. It is written that the court of CGM may pass any sentence authorized by law except a sentence of death or imprisonment for life or imprisonment for a term which may extend up to 7 years. But beyond 7 years, he cannot go. Another question to you people is, if the matter is there before the court of session, before the judicial magistrate, and the judicial magistrate is of the view that more punishment is required to be given, under which provision he will be capable for doing so? What is the relevant provision he will follow? Yes, who will give me the answer? If there is a case which is being tried by the judicial magistrate, the trial can be conducted by the magistrate, but the punishment which the magistrate want to give is beyond his powers, because as you people know that judicial magistrate first class is having the power only to pass the maximum punishment for 3 years period. So let us say that there is an offense under section 380 of IPC. There is an offense under 380 IPC, and the maximum punishment which can be given is 7 years, and judicial magistrate first class is a competent person to undertake the trial. But judicial magistrate first class can only give the punishment to the maximum of 3 years. सवाल समझ रहे हैं सभी लोग? नहीं समझ रहे हैं? सवाल मेरा बड़ा सिंपल है। एक ऑफेंस हुआ है, थेफ्ट का ऑफेंस है, आईपीसी के सेक्शन नंबर 380 के अंदर है, अंडर इन अ ड्वेलिंग हाउस द थेफ्ट हैज बीन कमिटेड। द ट्रायल कैन बी कंडक्टेड अकॉर्डिंग टू द सीआरपीसी बाय जुडिशियल मजिस्ट्रेट फर्स्ट क्लास, but the maximum punishment the judicial magistrate first class can give is 3 years, but in law under section 380 the maximum punishment which can be given is 7 years period. So if the magistrate of first class is of the view that I should be giving more punishment but I am not capable of doing so, under which provision he is competent to do that? Under which provision he is competent to do that? So I got the answers from you people. That is section number 325. Very good. So the case will be submitted to the Chief Judicial Magistrate under section 325 of CRPC. 325 talks about the concept of submissions. And once the matter is submitted, Chief Judicial Magistrate is having the competency to pass the punishment up to 7 years, and then he can move for that. Last magistrate, that is the magistrate of second class, what is the maximum punishment he can give? That is not exceeding 1 year, that is to the maximum of 1 year he can go, and the fine of rupees 5,000. जुडिशियल मजिस्ट्रेट सेकंड क्लास जो है वो 5,000 तक का फाइन लगा सकते हैं, एंड जुडिशियल मजिस्ट्रेट फर्स्ट क्लास जो है वो 10,000 रुपए तक का फाइन जो है वो इम्पोज कर सकते हैं। लेकिन क्या चीफ जुडिशियल मजिस्ट्रेट के ऊपर फाइन को लेके कोई रिस्ट्रिक्शन है? Do any restriction is over the chief judicial magistrate with respect to the fine he can impose? Yes. With respect to fine, do any restriction is there over the chief judicial magistrate? The answer is no. With respect to the fine, there is no restriction on the CJM. Okay, Shaktija, you are saying that committal under 323, as he has already tried the matter, you are rightly pointing out the thing, but section 325 is with respect to the committal proceedings, where the magistrate is of the view that the case is to be committed to the court of session. The case is better to be tried by the court of session. There 323 is to be followed up. But if the matter is already tried by the judicial magistrate first class, and he is of the view that more punishment is required to be given, but he is not empowered to do that, then in that scenario, section 325 submission proceedings will be taken up. Okay, submission proceedings will be taken up. Chaliye, coming to the next area of discussion, that is, if the sentence of imprisonment is to be given because the fine was imposed over the concerned person and he has defaulted in the payment of fine. Now, what will be the maximum imprisonment which we can give to that person? The point in section number 30 is, it is like this, you can understand over here. The person is liable for an offense for which the punishment is imprisonment of, let us assume that 1 year, and fine of rupees 1,000. Fine of rupees 1,000. Or both. Like this kind of an offense is there where the imprisonment is can be of 1 year, or fine of rupees 1,000, or both. Or fine can be without any limit also. Any such kind of a situation can be there. The court imposed fine over the party that is accused, but accused had defaulted in the payment of the fine. Now, for default of the fine, what is the maximum extent of imprisonment we can give to that person? What is the maximum extent of imprisonment we can give? So it is written in clause number B of this provision, that where the imprisonment has been awarded as a part of substantive sentence, the maximum can be 1/4 of the imprisonment. It cannot exceed 1/4. लिखा है ना, provided that the term is not excess of the powers of the magistrate, and it shall not exceed 1/4 of the term of imprisonment. So the point is like this. The point is like this. Like there is an offense for which the maximum punishment is 1 year, and the fine is also imposed over the party, and fine. Accused defaulted in payment of fine. Now, because there is a default from the part of the accused, with respect to this default, we can give additional imprisonment to him, and that imprisonment will be one fourth of the imprisonment which is there given in the particular offense. So 1 year ka one fourth आप कर लोगे, तो 1 year का one fourth means it is 3 months. So 3 months imprisonment will be given for the default of the fine. ये पूरा process जो IPC के अंदर भी है, whenever you see onward section number 53 till section number 70, till section number till which section the imprisonment portion is there under IPC. Yes, onward section number 53, which is the last provision. Yes, who will tell me? So someone is giving me the answer. That is one fourth of the competency of the magistrate as he has tried under section 65, where one fourth of the maximum extent of imprisonment. So combining both. Look what happens that if the power of the magistrate is not allowing him to go for that, then he cannot exceed his power. But if he is having the power, then the maximum imprisonment which can be given for the default of the fine is one fourth. That is the point. Okay, but my point is, yes, you are rightly pointing out it is correlated with the provisions of the IPC, that is section number 64, 65 onwards. All these provisions are being with respect to the same point. And सेक्शन नंबर 53 से कहां तक जाता है पनिशमेंट का एरिया आईपीसी में? आईपीसी का सवाल है, ये सेक्शन नंबर 75 तक जाता है. आर यू श्योर? सेक्शन नंबर 75 तक जाता है. 53 to 75, very good. So Pratibha, Shaktija, all of you are saying that 53 till 75, very good. So all these provisions are related to the punishments given in the Indian Penal Code, like what can be the kind of punishment, etc. Now another question which is important, that look what happens. There is a person who has committed multiple offenses. Multiple offenses means that person has committed, for example, housebreaking. Along with the housebreaking, he committed grievous hurt to someone. Thereafter, he committed robbery also. So, if such kind of offenses are there with respect to the single transaction, in a single transaction, multiple offenses are committed, what kind of punishment will be there? Like for each offense, there will be different punishment. Let us say that the punishment is for 445, the court has given, let us assume that 2 years period. For grievous hurt also, the court has given 2 years period. For the offense of robbery also, the court has given, let us assume 2 years period. So these punishments will run concurrently, or they will be running one after the other. So the answer to this thing is given in section number 31 of CRPC, which is clearly providing that where the punishments are given with respect to more than one offenses, such punishments will, when consisting of imprisonment, to commence one after the expiration of the other, unless the court directs that the punishments shall run concurrently. तो अगर कोर्ट ने डायरेक्शन दिया है कि punishments concurrently run करेंगी, then it will be accordingly. But अगर कोर्ट ने sentence order में ये नहीं लिखा है that the punishments will be running concurrently, then they will be running one after the other. Now, if the punishments are running one after the other, that is the consecutive sentences are there, what will be the maximum time period for which the punishment can be given? There is a restriction on this given by section number 31, clause number 2, proviso, and it is saying that where there is a consecutive sentences means one after the other. Like firstly 2 years period will over, then 2 years period will be over, then the third offense punishment will be getting over. These are the consecutive sentences. So in the cases of consecutive sentences, it shall not be necessary for the court, by reason only for the aggregate punishment for the several offences is in excess to the punishment which he is competent to inflict for a single offence. जैसे कि judicial magistrate second class is having the power to give the punishment of 1 year only. Judicial magistrate second class is having the power of 1 year only. Judicial magistrate first class is having the power to give the punishment for 3 years. Now, if multiple offenses are tried, consecutive sentence order is passed, and the aggregate of the punishment is going beyond the power of the magistrate, do there is any violation of the law? The answer is no, because section 31 clause number 2 is clearly saying it is not necessary for the court only by reason of the aggregate punishment being in excess to the punishment which is competent to inflict on the conviction of a single offense. But there is some restriction on this. The restriction is in no case the person sentenced to be imprisonment for a longer period than 14 years. मतलब कि in totality जो punishment है वो 14 years से ज़्यादा की नहीं होनी चाहिए. And the second condition is the aggregate punishment shall not exceed twice the amount of the punishment which the court is competent to inflict for a single offense. It means what? It means like this, that if there is the consecutive sentences passed by the judicial magistrate second class, then he cannot go beyond the twice of the punishment he can give for single offense. So for single offense he can give to the maximum of 1 year, and twice will be 2 years. So if he is giving the consecutive sentence order for multiple offenses, then maximum punishment which he can inflict is 2 years period. For judicial magistrate first class, it will be, because he can give for one offense 3 years to the maximum, twice will be 6 years. Judicial magistrate can go up to 6 years period if there is a consecutive sentence order passed by him. Thereafter, if it is chief judicial magistrate, the chief judicial magistrate is having the competency to give punishment up to 7 years period for one offense if it is allowed, then the twice will be 14 years. 14 years. So CGM can go up to the maximum of 14 years, because twice जो है वो भी 14 year बनता है, और जो क्लॉज की रिस्ट्रिक्शन है 31 के प्रोवाइजो के क्लॉज नंबर 1 की, वो भी 14 years तक पीरियड को ही अलाउ करवाता है. बट द मेन पॉइंट विच पीपल हैव टू अंडरस्टैंड कि जो भी हमारे असिस्टेंट सेशन जजेस हैं, द असिस्टेंट सेशन जजेस can give the maximum punishment up to 10 years for one offense. Twice will be 20 years, but he cannot go up to 20 years because there is a restriction that in no case you will go beyond 14 years period. So assistant session judge के cases में, if the consecutive sentence order is passed, multiple offenses are tried in one trial, the maximum imprisonment which can be given for the consecutive sentence order, it can be to the maximum of 14 years. It will not the twice of the punishment which he can give. That it will not be 20 years, rather it will be 14 years period. Because in दोनों में whichever is less, that is to be followed. Whichever is less, that is to be followed. So coming to the next point that is important for you people, I hope this point is clear to everyone. This point is clear to everyone. Chaliye, coming to the next area of discussion, that is onward section number 36. Onward section number 36. What are the important pointers with respect to your exam? Look, as whenever the case is there before a police officer, FIR is lodged, that the investigation starts. So generally the investigation is being carried on by the officer in charge of the police station or the investigating officers, and it is generally not being conducted by the superior officers. But do the superior officer has no power to do so? It is incorrect. Superior officer is having all the powers which are available to the officer in charge of the police station. Section 36 is very clear on this point, that the police officer superior in the rank to the officer in charge of the police station may exercise the same powers which can be exercised in the local area to which he is appointed. So section number 36 is relevant when you see section number 154 of the CRPC with respect to the FIRs. There also section number 36 is correlated with that. Section 154 clause number 3 is correlated with section number 36 of the CRPC. Now what is the correlation? Let me tell you people. that if you go to a police officer, you want to lodge an FIR, but the police officer refuses to do that. Officer in charge of the police station refuses to do that. The next step is you will go to the superintendent of the police. And if the superintendent of the police desires that, okay, I will personally investigate the matter. So, do he has the competency? The answer is yes. Section 36 empowers the superintendent of police, inspector general of police, and director general of police even to investigate the offense. Okay. Now section number 37, 38, 39 and 40, these are only the direct reading areas, and only the marginal headings are to be understood by you people. इतना ही समझना है, ठीक है? In section number 37 it is saying, okay, if the magistrate or the police requires the assistance of the public, will the public is bound to do that? The answer is yes. Public is bound to give the assistance to the magistrate or to the public or to the police officer whenever they are demanding their aid. Why they are demanding? Why they are demanding the aid of the public? That is, it may be possible that they are arresting someone, and for this purpose they need the assistance of someone. If someone is breaching the peace and public assistance is required, the police officer or magistrate can order anyone to give their assistance. In prevention of any injury attempted to be committed to any railway, canal, telegraph, public property, etc. So, if such kind of injuries can be there to railway, canal, telegraph, public property, then also the assistance of the public can be demanded via the authorities, because railway, telegraph, public property, etc. these are very important to maintain the connectivity. That railway, telegraph, etc. is important to maintain the connectivity. Next one is, if the police officer is executing a warrant, then if the assistance is required, section number 37 will take care of that. But if someone who is not a police officer and that person is executing a warrant, aid to a person other than the police officer executing a warrant, likha hai na, where the warrant is directed to a person other than a police officer, then such other person can also demand your aid. वो भी आपकी सहायता मांग सकता है, and you are bound to give your assistance to that person. So 37, 38 से basic चीजें कभी-कभी पूछी जा सकती हैं. Only the direct interpretation people have to understand. Section number 39, that public is required to give information with respect to certain offences to the authorities. So there is certain category of offences which is mentioned, like 121 till 126, waging of war, etc. offences against state is there. 143, 144, 145, unlawful assembly, rioting, etc. offences is there. Any offence which is related to the adulteration of foods, etc. If such kind of thing is there and you are having the knowledge of that, it is your duty, it is your moral as well as your legal duty to inform the authorities with respect to such thing. If any murder or attempt to any culpable homicide not amounting to murder under section 304, in such cases also, if you have any awareness with respect to such offense, it is your duty to inform the authorities. Section 364 capital A, that is kidnapping for ransom, is there. So these are the different categories of offenses. If the public is aware of that, public is bound to give the information with respect to such offense to the nearest police officer or to the magistrate, whosoever can be approached. So these are the different categories of offenses, like mischief against property, offense against house trespass, etc. So किसी भी offense के बारे में अगर आपको जानकारी है, आपको authorities को ये चीज बतानी होती है. Now section 40 is again duty of the officers employed in connection of the affairs to a village. So like for example, there is a village pradhan, okay, या village headman जिसको आप कहते हैं, that person, if he is aware with respect to certain offences which are specified in section 40, it is his duty to inform the authorities. It is his duty to inform the authorities, as in the last portion of this section it is specified that the officer employed in connection with the affairs of village means the members of the panchayat of the village including headman. तो जब भी किसी गांव में कोई प्रधान है या वार्ड के मेंबर्स होते हैं जो पंचायत के मेंबर बनते हैं, all those persons are considered to be the officers employed, and if they have any knowledge with respect to any offense, so they are duty bound to inform it to the authorities. Now next area, that is section number 41 onwards, it is important with respect to the exams, like in what cases the arrest can be there without warrant. Arrest can be there without warrant. So I will be making up a flowchart over here for you people so that you will be able to understand it very quickly. Look, arrest without warrant. Multiple categories are there. Number one, if any cognizable offense is committed in the presence of the police officer, in the presence of the police officer, then also you can go for arrest of such person without warrant. It is written that whosoever commits in the presence of the police officer a cognizable offense. Further, if any person gives any credible information or reasonable suspicion is there against someone, or reasonable complaint is filed in the court of reasonable complaint is filed before the authorities, and the offense which is being mentioned, it is a cognizable offense and it is punishable up to 7 years period, not exceeding 7 years, up to 7 years. And the police officer is satisfied that okay, the information, complaint, etc. Is there, and we have a reason to believe that yes, the offense has been committed, and the police officer is also satisfied that if such person is not arrested, he might commit another offense. It is required that arrest should be done because proper investigation can be done only after that. Arrest is required because if the arrest is not done, the person may go for disappearing or tampering of the evidences, etc. The police officer is of the view that if we don't go for the arrest, this person can go for inducement, threat, or promise with respect to the offense which he had committed, and he can give an inducement, threat, or promise to the witnesses whosoever are acquainted with the facts of the case. Or if this person is not arrested, his presence in the court of law cannot be ensured. So if such kind of things are there, you have to mention it, you have to record the reasons in writing, and then only you will be making the arrest. This is generally called as a checklist, which is to be prepared by a police officer, that if the offense is there which is punishable with less than 7 years, why the arrest is required. And if any of these 5 pointers is available, if any of these 5 pointers are available, the police officer can go for the arrest of such person. But if any offense is there for which the punishment is more than 7 years, punishment is more than 7 years, and the information is credible in nature, then the police officer can arrest such person, and there is no requirement to see all these above written factors which we recently डिस्कस. ठीक है, तो उनमें फिर आपको ये देखने की जरूरत नहीं होती दैट दिस पर्सन इज गोइंग टू टेम्पर द एविडेंसेस, और ही मे गो फॉर द इंड्यूसमेंट और थ्रेट टू द विटनेसेस एटसेट्रा. अगर अपराध 7 साल से ज्यादा के लिए पनिशेबल है, द ऑफेंस इज पनिशेबल विद मोर देन 7 years, then definitely you can go for the arrest of such person, provided you must be having a reason to believe that such person has committed the offense. अब और कौन-कौन सी कैटेगरीज हैं where you can go for the arrest? Like if a person is a proclaimed offender, then the arrest can be there. If a stolen property is found in the possession of someone, then the arrest can be there of such person without warrant. If someone obstructs the police officer and the police officer was performing his duty and you creates an obstruction, then clause number E provides that of such person also the arrest can be there. If someone is a deserter from the armed forces, उसका arrest किया जा सकता है. If any person against whom a reasonable complaint or credible information is there that extradition proceedings are there against such person. So if the person who has committed an offense outside country and he is in India, we got a reasonable complaint or information that yes, that person is required to be arrested, then we can go for the arrest without warrant. And it is related to section 356 also. 356, that is related with that once the convicted person is released, there are certain rules which he has to obey. If he violate any of the rule, then he can be arrested. Now these are the basic pointers that when we can go for the arrest of someone. Now some important cases with respect to the arrest, that is very very important judgment, that is Arnesh Kumar versus State of Bihar 2014 Supreme Court. In this particular case, different guidelines were given that when the police officer is going to arrest someone when the arrest is not required, in what cases the the notice can be issued, notice for appearance can be issued to the person, and these are the basic guidelines which you people can see. I have mentioned over here that the state government will give instruction to the police officer not to automatically arrest someone when the case is registered. And though Arnesh Kumar judgment was specifically on the point of 498 capital A, but the guidelines are have some broader extent. 498 capital A, arrest should only be considered if the situation aligns with the criteria outlined in section number 41 of the CRPC. All police officers should have a checklist, as the 5 pointers which I mentioned you people, that is the checklist. All police officers should have the checklist, and if they find that okay, the arrest is required only, then they will be going for that. If the police officer finds that the notice of appearance will be given to the concerned person and he can appear before the authorities, then it is not required to go for the arrest of such person. So the question which comes is, under which provision of CRPC the checklist is provided? So it is section number 41 itself. Which case law provides that in every case you will not be going for the arrest, rather the police officer will have to maintain a checklist? That is section number there is Anish Kumar versus State of Bihar. Now recently in 2023 also, because Arnesh Kumar guidelines were not followed by the state authorities. So Honorable Supreme Court in Muhammad Ashfaq Alam versus State of Jharkhand 2023, very very important judgment. Again the directions were issued to the authorities that please follow the guidelines given in Arnesh Kumar versus State of Bihar. तो इस judgment को अगर आपने पहले नहीं किया है तो just mention it, that in Muhammad Ashfaq Alam versus State of Jharkhand 2023, the Supreme Court has given the direction that the guidelines given in Arnesh Kumar versus State of Bihar must be followed. Okay, so this is important judgment. And apart from this, section number 41 capital A, which talks about notice of appearance, like if the police officer has the competency to arrest a person as per section 41, but he is of the view that we are not going to arrest this person, we will issue a notice, and this notice of appearance will be issued to the concerned person, and if that person complies with the notice, he appears on the dates required, then it is not required to arrest till the time he is following the directions given by the authorities. But the moment he fails to comply with the terms of the notice, or he is unwilling to identify himself, then in such case the authorities can go for the arrest of such person. ठीक है, तो कभी कभी यहाँ से DGS पे सवाल आया है पहले. From this particular point there is a question in DGS that when a person against whom the notice of appearance is issued can be arrested. So section number 41 capital A clause number 4 is the relevant provision on this point. Now with respect to this, there is another important judgment which was decided by the Honorable Delhi High Court, that is Amandeep Singh Johar versus NCT of Delhi. It is of 2018 Supreme Court. In this particular case also, Delhi High Court has pointed out the guidelines given by the Honorable Supreme Court in Arnesh Kumar case. उन्हीं guidelines को यहाँ पे repeat किया गया कि whenever the notice of appearance is issued to a particular person and the person does not appear, okay, then what can be the repercussions of that? And if the accused appears and he needs some extensions, etc., then what will be the time period for that? As in point number 6 I will read over here, the notice of appearance in terms of 41 capital A must be served on the accused within 2 weeks from the institution of the case. So 2 weeks time period is mentioned, and it was given in the Arnesh Kumar judgment also, which may be further extended to the subsequent may be extended by the superintendent of police of a district for the reasons to be recorded in writing. So ये कुछ एक चीजें हैं जो आपको ध्यान में रखनी है कि 41 कैपिटल ए के अंदर जब नोटिस दिया जाता है, within how much time the notice must be served to the accused person, that is within 2 weeks period. Okay, so ये अनिश कुमार की जजमेंट को ही अमनदीप सिंह जौहर की जजमेंट में दिल्ली हाई कोर्ट ने फॉलो अप किया. इसके साथ साथ 41 कैपिटल बी that is with respect to the procedure of arrest and the duties of the person making the arrest, uske upar hai. Now, what is important in this particular provision? You just mentioned that okay, when this provision is introduced in the CRPC, कभी यहाँ से सवाल आ जाता है कि amendment कब हुआ था? So 2010, that is 1st of November 2010 is the date on which these provisions were incorporated. Question comes that whenever the memorandum of arrest is there, it must be attested by at least how many witnesses? So one witness must be there. In DGS in 2015, I believe there was a question that memorandum of arrest must be attested by how many person? 2%, 1%, 3%, 5%. So the right answer is it must be attested by at least one witness. Thereafter, the other requirements is that the person whosoever is going to arrest the offender, his name should be visible, accurate and clear identification of the name should be there. Memorandum of arrest will be prepared. It must be attested by at least one witness who may be a member of the family of the person arrested or he may be any other respectable member of the locality. तो इन सारी चीजों का आपको ध्यान रखना है. Apart from this, 41C, that is talking about the control rooms. Question comes that where the control room is to be established, who will establish? The state government is going to establish these control rooms. कहाँ पे establish होंगे? Either in every district they have to go for that, and at the state level also there will be a control room. And state level पे जो control room बनता है वो पुलिस headquarters पे बनता है. ठीक है, जहाँ पे भी स्टेट का पुलिस हेडक्वार्टर है, देयर यू विल बी हैविंग अ स्पेसिफिक कंट्रोल रूम फॉर दैट. और हर जिले के अंदर इन एवरी डिस्ट्रिक्ट देयर विल बी द कंट्रोल रूम. देयर आफ्टर 41D, that if a person is arrested, can he meet an advocate of his choice? The answer is yes, he can meet an advocate of his choice, but not throughout the interrogation. Not throughout the interrogation. This meeting is not allowed. Okay, if the interrogation is going on, advocate will be sitting over there. How the interrogation will be taken up? So that is why it is saying that every person whosoever is arrested and interrogated by police, he is entitled to meet his advocate through the during his interrogation, but not throughout interrogation. इसका ध्यान आपको रखना है. बस इसके बाद आपका जो नेक्स्ट एरिया रहेगा, that is section number 42. Section 42 कह रहा है कि if a person who has committed a non-cognizable offence and that offence is committed in the presence of the police officer, the police officer asks the name and address of such person. Non-cognizable offence है, गंभीर अपराध नहीं है, संज्ञेय अपराध नहीं है, ठीक है, असंज्ञेय अपराध है. तो in the presence of police officer that offence is committed, offence is non-cognizable in nature, the police officer demands the name and residence of such person and the person does not mentions his name and residence. If the name and residence is not disclosed, the person can be arrested. The person can be arrested, but the moment his true name and address is ascertained, he will be released. But if within 24 hours his name and address is not disclosed, then he will be immediately forwarded before the judicial magistrate under section 167 of the CRPC. Okay, thereafter the question comes that under which provision a private person can go for the arrest. So private person arrest कर सकता है provided the offence should be bailable and cognizable. And cognizable, very important. Non-bailable and cognizable offence. Plus, if the offender is a proclaimed offender, then also the private person can go for the arrest of such person. So there are two situations where the private person can arrest someone. Number one is if the offender is a proclaimed offender, then you can go for the arrest of such person. Number two, if the offence is non-bailable in nature, and offence is cognizable in nature, in such kind of cases, you can go for the arrest of such person, and this arrest is by the private person. Next section that is important for you people, that is, can a magistrate go for the arrest? The answer is yes, magistrate can arrest any person if the offence, either cognizable or non-cognizable, has been committed. The offence is there in the presence of the magistrate. Magistrate may be executive or judicial, and the magistrate is of the view that this person is to be taken in the custody. Magistrate may directly arrest him, or magistrate may order someone to arrest such person. So this is point number 1. And clause number 2 says that if any magistrate may at any time time direct the arrest of a person of whose arrest he is competent at the time to issue warrant. ये दो चीजें हैं कि if the offense is committed before the magistrate itself, in the presence of the magistrate, then the magistrate can order the arrest or magistrate can himself arrest. And the second situation is if a person is there for whose arrest a warrant can be issued by the magistrate, and the magistrate finds that okay, this person is there and it is a local jurisdiction of the magistrate can directly arrest such person or magistrate can order the arrest of such person. ठीक है, तो 44 के दोनों क्लॉजेज आपके लिए रेलेवेंट है. इसके बाद आपका सेक्शन नंबर 46 आपके लिए रेलेवेंट है, हाउ द अरेस्ट इज मेड. तो जनरली द प्रोसेस ऑफ अरेस्ट इज दैट फर्स्टली यू विल बी आस्किंग अ पर्सन टू सबमिट टू द कस्टडी. अगर वो कस्टडी में सबमिट नहीं होता है, देन द नेक्स्ट ऑप्शन इज टू टच एंड कन्फाइन द बॉडी ऑफ द पर्सन अरेस्टेड. Okay, directly touch and confine नहीं करेंगे. Firstly, you will be asking that person to submit to the custody by word or action. You will be asking this. If he does not submit, then you can go for touching and confining of the body of such person. Number 2, can you exercise force? The answer is yes. The person who is required to be arrested, if he forcibly resist, then you can use all means necessary to effect the arrest. Okay, but if a woman is to be arrested, then generally a woman police officer is required. But if the circumstances are of exceptional nature, then the woman police officer, and if the woman police officer is not available, still the arrest can be there, but the male is restricted to touch the body of the woman. ठीक है, तो इसको मैं सिंपल अगर तरीके से समझाऊं तो जनरली इफ द वुमेन इज टू बी अरेस्टेड, तो फीमेल पुलिस ऑफिसर या फीमेल ही आपको चाहिए अरेस्ट करने के लिए. लेकिन इफ द सर्कमस्टेंसेस आर कॉन्ट्रेरी टू दिस, if the circumstances are of exceptional nature, then the arrest can be made by a male police officer also, but the police officer will not touch the woman at the time of arrest. तो आप टच नहीं कर सकते, लेकिन अगर आप सबमिशन में सिर्फ बाय वर्ड्स और एक्शन से आप अगर उसको कस्टडी में ले ले, सो इट इज गुड इनफ. नंबर 2, that is in clause number 4 it is mentioned that after the sunset and before sunrise no woman will be arrested. After sunset, before sunrise, no woman will be arrested. And if the circumstances are of exceptional nature, then, and it is required that okay, there is a sunset or sunrise, but yes, the arrest is required to be done. So the woman police officer will have to make a written report, will have to obtain a permission of the magistrate of first class, and then only the arrest will be there. ठीक है, इसके साथ सेक्शन 47 में सर्च से रिलेटेड इशू है, आपको बस सेक्शन का ध्यान रखना है. सेक्शन 48 में it is provided that if you are arresting someone without warrant, then you can pursue such person to any place within India. इंडिया में कहीं पे भी जाके आप उस व्यक्ति को अगर अरेस्ट करना चाह रहे हो, you can go for that. Next one is whenever you are arresting someone, तो कितना आप उसको restrain करोगे, तो लिखा गया है that no unnecessary restraint to prevent, no unnecessary restraint is there. आप सिर्फ उसको उतना रिस्ट्रिक्ट करेंगे ताकि वो व्यक्ति भागे ना, बस. ठीक है, the restraint should not be absolutely, but the restraint should be to that extent that you are preventing the escape of that person. Thereafter, section number 50 is there, which talks about that if a person is arrested, the authorities are bound to inform the grounds of arrest to such person, and if there is a right to bail, they will also be informing that yes, you have a right to bail. Section number 50 capital A, obligation of the person making the arrest. जोगिंदर कुमार वर्सेस स्टेट ऑफ यूपी के जजमेंट से 50 कैपिटल ए का origin हुआ, that whenever the arrest is done, the police authorities are bound to inform the relatives or to the nominated person that this person is arrested, where this person is detained, कहाँ पे ये व्यक्ति रखा गया है, सारी चीजें आपको बतानी पड़ती हैं. You have to make a proper register of that. And whenever you will be producing the person before the magistrate, it is the duty of the magistrate also to look after that whether the obligations were discharged by the authorities or not. इसके बाद 51 है आपका, that is search of the arrested person. जब भी सर्च आप करोगे यू कैन गो फॉर दैट, बट विद रिस्पेक्ट टू द वुमेन द सर्च विल बी डन बाय द फीमेल ओनली एंड इट शुड बी विद स्ट्रिक्ट रिगार्ड टू डिसेंसी, इट शुड बी विद स्ट्रिक्ट रिगार्ड टू डिसेंसी। 52 के अंदर कोई भी अगर वेपन सीज किया गया है तो आप उसको सीज कर लेंगे फ्रॉम द एक्यूज्ड पर्सन। 53 के अंदर दैट इज एग्जामिनेशन ऑफ द एक्यूज्ड एट द रिक्वेस्ट ऑफ द पुलिस ऑफिसर, कि अगर एक व्यक्ति एक्यूज्ड है और उसका एग्जामिनेशन करवाने की जरूरत है तो यू कैन गो फॉर दैट, बट दिस विल बी डन बाय अ पर्सन नॉट बिलो द रैंक ऑफ द सब इंस्पेक्टर। द नेक्स्ट थिंग इज 53 कैपिटल ए, that is examination of a person accused of the rape by the medical practitioner। 54 जो है that is pointing out that if a person is arrested, उसका अगर मेडिकल होगा तो 54 के अंदर होगा, तीनों प्रोविजंस में डिफरेंस है। 54 is talking about if any person is arrested, उसका मेडिकल 54 के अंदर होगा। accused, whenever a person against whom the case is registered, that person will be called to be the accused person, और उसका अगर मेडिकल होगा तो that will be done under section number 53। और अगर कोई भी रेप का accused person है उसका मेडिकल 53 के कैपिटल ए के अंदर किया जाता है। और आप लोग कमेंट्स में बताएंगे कि रेप विक्टिम का मेडिकल कौन से प्रोविजन के अंदर होगा, रेप विक्टिम का मेडिकल कौन से प्रोविजन के अंदर होगा, यू पीपल विल बी मेंशनिंग इन द कमेंट बॉक्स। इसके बाद 54 कैपिटल ए, दैट इज टॉकिंग अबाउट द आइडेंटिफिकेशन परेड। टेस्ट आइडेंटिफिकेशन परेड जब होता है, सो इफ द पर्सन हु इज अरेस्टेड इज रिक्वायर्ड टू बी आइडेंटिफाइड बाय द विटनेस फ्रॉम बाय सम अदर पर्सन दैट इज विटनेसेस, then the officer in charge of the police station will direct the person to subject himself to the identification in the manner as the court may deems fit। तो टेस्ट आइडेंटिफिकेशन परेड का पूरा कॉन्सेप्ट है, कैसे टीआईपी होगा, who will be conducting it, तो जनरली एग्जीक्यूटिव मैजिस्ट्रेट्स will be conducting the test identification parades। अगर जिस व्यक्ति ने आइडेंटिफाई करना है वो व्यक्ति मेंटली या फिजिकली डिसेबल्ड है, मतलब द पर्सन हु इज गोइंग टू आइडेंटिफाई द एक्यूज दैट पर्सन इज मेंटली और फिजिकली डिसेबल्ड, तो उस आइडेंटिफिकेशन प्रोसेस का वीडियोग्राफी होना जरूरी है। इट इज रिक्वायर्ड दैट द वीडियोग्राफी शुड बी देयर एंड इफ रिक्वायर्ड टू स्पेशल एजुकेटर्स एटसेट्रा शुड आल्सो बी प्रेजेंट ऑन द स्पॉट। इसके बाद आपका रेलेवेंट सेक्शन है 55 कैपिटल ए। 55 कैपिटल इज रेलेवेंट दैट व्हेनेवर द पर्सन इज अरेस्टेड उसकी सेफ्टी का ध्यान जो है वो रखना पड़ेगा। इट शिल बी द ड्यूटी ऑफ द पर्सन हैविंग द कस्टडी ऑफ द एक्यूज टू टेक रीजनेबल केयर ऑफ द हेल्थ एंड सेफ्टी ऑफ द एक्यूज। तो जिस भी व्यक्ति के पास कस्टडी है, पुलिस ऑफिसर्स की बात हो रही है, तो उनको ही कस्टडी का ध्यान रखना है, हेल्थ एंड सेफ्टी का ध्यान रखना है अरेस्टेड पर्सन की। Thereafter section number 56 ट्रांजिट रिमांड्स की बात करता है कि whenever a person is arrested from somewhere else, तो कहीं पे भी अगर उसको अरेस्ट किया गया है, अरेस्ट होने के बाद उसको नियरेस्ट पुलिस स्टेशन में हम लेके जाते हैं और वहां से फिर आप ट्रांजिट रिमांड लेके उसको दूसरी जगह में लेके जाते हो। तो 56 is altogether about transit remand and transit orders। Whenever the person is arrested, he is required to be taken before the officer in charge of the police station or before the nearest magistrate। तो अगर आपने आउटसाइड द जुरिस्डिक्शन अरेस्ट किया है तो आपको वहां से ट्रांजिट के ऑर्डर्स लेने पड़ते हैं। ट्रांजिट के ऑर्डर्स पे इसको ट्रांजिट रिमांड कहा जाता है। फिर आप जिस भी कोर्ट की जुरिस्डिक्शन में लेके आना चाहते हो वहां पे आप इस व्यक्ति को लाओगे। सेक्शन 57, whenever the person is arrested without warrant, 24 घंटे से ज्यादा इसको आप डिटेन नहीं करोगे। 24 घंटे से ज्यादा अगर डिटेन करना आपको लगता है जरूरी है, you must be taking it after the permission of the magistrate under section 167 of the CRPC। 58 में पुलिस हैज टू रिपोर्ट द एप्रीहेंशंस टू द डिस्ट्रिक्ट मैजिस्ट्रेट। जिस भी व्यक्ति को अरेस्ट किया गया, आज मान लीजिए एक पर्टिकुलर डे पे जितने भी लोग अरेस्ट हुए उन पूरे लोगों का एक रिपोर्ट तैयार होकर डिस्ट्रिक्ट मैजिस्ट्रेट के पास फॉरवर्ड किया जाता है। कोई भी व्यक्ति जिसको आपने अरेस्ट किया, अगर उसको डिस्चार्ज करना है, उसे बॉन्ड भरवा के यू कैन रिलीज दैट पर्सन whosoever was apprehended। एक व्यक्ति अरेस्ट हुआ, अरेस्ट होने के बाद ही ट्राइंग टू मेक अप एन एस्केप, so you have a power to again take the custody of such person। so ये सेक्शन नंबर 60 तक के जितने भी सेक्शंस हैं, every section is important onward। सेक्शन नंबर 6 till section number 60 every section is important with respect to the multiple choice questions। ठीक है, with respect to the multiple choice questions बहुत बार सवाल आते हैं। different judgments also which are relevant I had discussed over here। इसके बाद आपका सारा एरिया जो है टिल सेक्शन 100 थोड़ा सा सेग्रीगेटेड है, हर एक चीज नहीं पढ़नी, मैं बता रहा हूँ क्या क्या पढ़ना है आपको। चैप्टर नंबर 6 में एज इट इज टॉकिंग अबाउट द फर्स्ट पार्ट इज टॉकिंग अबाउट समन्स। सेक्शन नंबर 61 फॉर्म ऑफ समन्स आपको ध्यान में रखना है कि समन्स कैसे बनाए जाएंगे। तो समन्स शैल बी इन राइटिंग एंड इन डुप्लीकेट साइंड बाय द प्रिजाइडिंग ऑफिसर। ठीक है। इसके बाद सेक्शन नंबर 62 है समन्स की सर्विस कैसे होगी। तो समन्स शैल बी सर्व्ड बाय द पुलिस ऑफिसर, और अगर स्टेट गवर्नमेंट ने कुछ रूल्स बना रखे हैं तो दोस रूल्स मस्ट बी फॉलोड। ठीक है। इसके बाद एक सवाल बहुत बार पूछा जाता है कि समन्स जब सर्व होंगे क्रिमिनल केसेस में, तो क्या आप किसी व्यक्ति के सर्वेंट को समन की सर्विस कर सकते हो? द आंसर इज नो। सेक्शन नंबर 64 कहता है दैट व्हेनेवर द समन सर्विस इज टू बी डन, इट कैन बी सर्व्ड टू द एडल्ट मेल मेंबर ऑफ द फैमिली। अंडरलाइन कर लेंगे, स्टार लगा लेंगे, एडल्ट मेल मेंबर ऑफ द फैमिली, सेक्शन नंबर 64, adult male member of the family, but a servant is not a member of the family. Servant को आप member नहीं मानते तो servant को अगर सर्विस हुई है that is not a valid service. ओके इसका ध्यान रखना। सिविल केसेस में मामला डिफरेंट है। सिविल केसेस में किसी भी एडल्ट को समन्स की सर्विस हो जाती है। क्रिमिनल केसेस में ओनली टू द एडल्ट मेल मेंबर ऑफ द फैमिली, टू सच पर्सन ओनली द सर्विस कैन बी डन। इसके बाद आप लोग सेक्शन नंबर 70 पे आओ विद रिस्पेक्ट टू वारंट, जो एरिया इंपॉर्टेंट है मैं आपको बता रहा हूँ। सेक्शन नंबर 70, वारंट जो है वो कैसे बनेगा। वारंट मस्ट बी इन राइटिंग, इट शैल बी साइंड बाय द प्रिजाइडिंग ऑफिसर एंड इट शैल बियर द सील ऑफ द कोर्ट। दैट इज वेरी इंपॉर्टेंट। जब तक वारंट कैंसिल नहीं हो जाएगा तब तक ये एग्जिस्टेंस में ही रहेगा। द वारंट until it is cancelled it will remain in force और until it is executed। तो या तो आपको इसको कैंसिल करवाना पड़ता है या ये एग्जीक्यूट जब होगा उसके बाद ही इसकी वैलिडिटी खत्म होती है। अदरवाइज वारंट विल रिमेन इन फोर्स until it is cancelled और until it is executed। ये दोनों चीजें ध्यान में रखनी है, until it is cancelled और until it is executed। Number 2, that if the warrant is a kind of a bailable warrant, okay, then in the warrant itself it will be mentioned that okay, when this person will come to you for arrest and he detains you and you deposit a certain amount or a bond is executed by you, he will release you then and there। ठीक है, तो वो सिक्योरिटी आप ले लेंगे और उस व्यक्ति को रिलीज कर देंगे। ये बेलेबल वारंट्स के लिए प्रोसेस जो है ये अप्लाई किया जाता है। इसके बाद आपके लिए रेलेवेंट सेक्शन है सेक्शन नंबर 77, दैट इज अगर कभी भी वारंट एग्जीक्यूट करना है तो कहां तक जा सकते हो। तो वारंट ऑफ अरेस्ट में बी एग्जीक्यूटेड एट एनी प्लेस इन इंडिया। एट एनी प्लेस इन इंडिया यू कैन गो एंड यू कैन एग्जीक्यूट द वारंट। ठीक है, बिकॉज वारंट्स अगर आपके पास है, आपके पास एक लीगल अथॉरिटी है अरेस्ट करने की, एंड यू कैन गो एनीवेयर। ठीक है, इसके बाद आपके लिए जो रेलेवेंट सेक्शन रहेगा दैट इज सेक्शन नंबर 82 में आओ विद रिस्पेक्ट टू द प्रोक्लामेशन। प्रोक्लामेशन से पिछले 3-4 बार से डीजीएस में काफी बार सवाल पूछे गए हैं, सो वी विल बी डिस्कसिंग सेक्शन नंबर 82 नाउ। देखो, व्हेनेवर द प्रोक्लामेशन इज टू बी इशूड, प्रोक्लामेशन को हिंदी में उद्घोषणा कहा जाता है, दैट इफ अ पर्सन हु इज ट्राइंग टू abscond, if the person is absconded, we can say the warrants are not executed, then against such person the proclamations will be issued, and the proclamations can be issued against any person। तो बेरेक्ट में आपके लिखा होगा any person, just mention any person includes accused, witness as well as surety। जरूरी नहीं है कि प्रोक्लामेशन केवल एक्यूज के अगेंस्ट ही जारी होगा। कोई भी व्यक्ति जो वारंट्स को अवॉइड कर रहा है उसके अगेंस्ट प्रोक्लामेशन जारी हो सकती है। ही कैन बी एन एक्यूज, ही कैन बी अ विटनेस, ही कैन बी अ श्योरिटी आल्सो। ठीक है, इसके साथ साथ what is the next important thing, you people just mark section 82 clause number 4। in 82 clause number 4 there are certain sections of IPC mentioned like section 302, 304 etc. if the accused person against whom the proclamation has been published, that person had committed an offense under these provisions of IPC like murder, kidnapping etc. is there, then such person, if he does not appear after the proclamation is issued, then the person is to be pronounced as a proclaimed offender। क्वेश्चन आता है proclaimed offender कौन से प्रोविजन के अंदर रखा गया है। सो 82 के क्लॉज नंबर 4 के अंदर है। एक और चीज जो आपके लिए रेलेवेंट है, दैट इज वंस द प्रोक्लामेशन इज इशूड, what will be the time given to the person to appear before the court? What will be the time given? So the time is that at least you will be giving 30 days time to such person to appear and to represent him. So 30 days कम से कम उसको दिए जाते हैं. You just see in your respective barracks, आपके पास barrack होगा 82 में ही, in section 82 itself, first paragraph last line, that at a specified place and time not less than 30 days from the date of publishing of the proclamation. So it is mentioned over there. यहाँ पे ये थोड़ा सा skip हो गया, तो वहाँ पे आप 30 days जो है वो मानते हैं. नेक्स्ट वन इज, ये भी सवाल जो अगला है सेक्शन नंबर 83 से काफी बार अलग अलग स्टेट्स में आता है. Look what happens that once you issue the proclamation, you have the option to attach the property of the person simultaneously, or you will be attaching the property after the issue of the proclamation. जैसे कि आज proclamation issue हुआ और you will be giving at least 30 days period, और 30 दिन खत्म होने के बाद after the expiry of 30 days you may go for the attachment. एक तो ये प्रोसेस है. दूसरा प्रोसेस ये है that the moment you are issuing the proclamation, simultaneously you are ordering the attachment of the property of the concerned person. तो ये क्या हो, दोनों चीजें क्या है, क्या डिफरेंस है? Just see what is written over here, that in section 83 I am talking about, that the court issuing proclamation under section 82 may, for the reasons to be recorded in writing at any time after the issue of proclamation, underline करेंगे इसको, after the issue of proclamation, order the attachment of the property, movable or immovable, both belonging to the proclaimed person. कि आपने proclamation जारी किया, proclamation के बाद after that you are attaching the property. It may be movable property, it may be immovable property, but there are certain cases where the proclamation as well as the attachment can be done simultaneously. In what cases it can be done? It is written that where a person against whom a proclamation is to be issued, जिसके against proclamation अभी issue होना है, उसकी बात हो रही है, is about to dispose of the whole or part of the property, or is about to remove whole or part of the property from the local jurisdiction of the court. अगर उस व्यक्ति ने प्रॉपर्टी कोर्ट की जुरिस्डिक्शन से बाहर निकाल दी या करने वाला है या रिमूव कर देगा प्रॉपर्टीज को, तो आप प्रोक्लामेशन के साथ ही अटैचमेंट का ऑर्डर जारी कर सकते हैं. हर केस में करने की आवश्यकता नहीं है, लेकिन अगर ये दो सिचुएशंस आपको मिल जाए, इफ यू आर गेटिंग दीज टू सिचुएशंस, then along with the proclamation you may go for the attachment of the property simultaneously. Now once the property of the person is attached, if someone want to raise an objection to the attachment, ठीक है, एक व्यक्ति था, एक्यूज हो सकता है, विटनेस हो सकता है, श्योरिटी हो सकता है, जिसके अगेंस्ट आपने प्रोक्लामेशन जारी किया, बिकॉज that person was avoiding the warrants and summons, he was not appearing before the authorities, proclamation issued, we, after the proclamation is there, we attach the property of that person, and someone had any objection with respect to the attachment. So within how much time the objection is to be raised? So it is mentioned in section number 84, very important point, within 6 months. Within 6 months you have to raise objection with respect to the attachment of the concerned property. You can say this property belongs to me and this property does not belong to the proclaimed offender, so this property should not be attached. If you have such kind of objections, you may raise it within 6 months. इसके साथ साथ, if the claim is disallowed, if your claim or objection is disallowed, you have 1 year period for filing a civil suit and to establish your right. तो आप सिविल कोर्ट में अपना राइट क्लेम करने के लिए 1 साल के अंदर जा सकते हैं. So it is mentioned in section number 84 clause number 4. ये दोनों चीजें इंपॉर्टेंट है. अगर किसी को ऑब्जेक्शन उठाना है 6 महीने के अंदर उठाना है, और अगर आपका ऑब्जेक्शन डिसअलाउ हो गया तो 1 साल के अंदर आप सिविल कोर्ट में टाइटल क्लेम करने के लिए सिविल सूट फाइल कर सकते हैं. सेक्शन नंबर 85 कि अगर किसी भी व्यक्ति की प्रॉपर्टी को आपने अटैच करके रखा है और वो व्यक्ति जो है उसकी प्रॉपर्टी को बेचना है, तो प्रॉपर्टी कितने समय तक बेची नहीं जाएगी? तो लिखा है if the property is attached and the person is not appearing, it shall not be sold until the expiry of the 6 months from the date of attachment. कि आपने एक व्यक्ति की प्रॉपर्टी अटैच कर ली, the property is attached, now you are compelling that person to appear before the court of law, that person is not appearing till the period of 6 months, you cannot sell out that property, because attachment के बाद next option होता है कि प्रॉपर्टी को सेल आउट किया जाए, लेकिन 6 महीने तक सेल नहीं किया जाएगा. नंबर टू, सेल करना कोई मैंडेटरी नहीं है. इट इज नॉट मैंडेटरी दैट यू आर गोइंग टू सेल आउट द प्रॉपर्टी, बट इफ the concerned person whose properties are attached, that person appears before the court within 2 years from the date of attachment. Then, if he voluntarily appears before the court, then his property will be de-attached, provided he has to prove that he has not absconded or concealed himself from for the purpose of avoiding the executions of the warrant. कि मान लो एक व्यक्ति की प्रॉपर्टी अटैच हुई, अटैच होने के बाद हम उसको कहा कि भैया अब आपको आना पड़ेगा, नहीं तो आपकी प्रॉपर्टी बेच दी जाएगी. 6 महीने तक तो हम बेचेंगे नहीं, लेकिन मान लो आपने प्रॉपर्टी सेल आउट नहीं की, तो प्रॉपर्टी इज नॉट सोल्ड आउट till the 2 years period, and within the 2 years period that person voluntarily appears before the court, that person satisfies the court that where he was, वो क्यों नहीं कोर्ट में आ रहा था. अगर कोई sufficient reason बता देता है तो कोर्ट उसकी प्रॉपर्टी को अटैचमेंट से बाहर निकाल देगा, और जो भी खर्चा एक्सेट्रा कोर्ट का हुआ था वो हम उससे लेंगे. और अगर वो प्रॉपर्टी बेच दी गई है, if the property is sold, then whatever the proceeds of sale is, that proceeds will be given to that person. ओके इसके बाद जो और आपके सेक्शन 100 तक का एरिया है उस पे आप क्विक टेक कर ले इसका. ठीक है कि सेक्शन नंबर 87 के अंदर इफ देयर इज अ समन्स केस, you want to issue warrant, you can go for that, and if there is a warrant case and you want to issue summons, you can go for that. Section number 87 is to be read together with section number 204 clause number 5 of CRPC. 204 क्लॉज नंबर 5 के साथ पढ़ा जाता है इशू ऑफ वारंट इन ल्यू ऑफ और इन एडिशन टू समन्स. समन्स केस है, ध्यान से समझना, समन्स केस है. हमारी जनरल प्रैक्टिस होती है कि समन्स केसेस में समन ही जारी किए जाएं. समन्स केसेस कौन से हैं? जिनमें पनिशमेंट 2 साल से कम की है. व्यक्ति विशेष को बुलाने के लिए, टू कॉल अप द पर्सन, वी विल इशू समन्स, वी विल नॉट डायरेक्टली इशू वारंट. बट सेक्शन 87 empowers the court that the court can issue warrant in addition to the summons or in lieu of the summons, provided if the court is of the view that the person will not obey the summons, warrants are required to be issued, the court may go for that. ठीक है. इसके बाद आपका सेक्शन नंबर 88 हेडिंग का ध्यान रखना है, that is bond is to be signed for appearance before the authorities. सेक्शन नंबर 91 निकालो. Take out section number 91. Summons with respect to the production of things. यहां से कभी कभी सवाल आता है, I had mentioned over here, क्या सवाल आता है that section 91 किसके ऊपर अप्लाई करता है? तो complainant and witnesses के ऊपर अप्लाई करेगा, because if the person who has filed the complaint or the witnesses, they have certain documents in their possession, we can compel them to produce those documents before the court of law, but this provision does not applies to the accused person. accused के ऊपर section 91 अप्लाई नहीं करता है, डायरेक्ट पे लिख लेना. section 91 is only a declaratory and a discretionary provision. ये जरूरी नहीं है कि आप व्यक्ति के ऊपर ऑर्डर दे ही दो डॉक्यूमेंट प्रोड्यूस करवाने का. इफ यू फाइंड दैट ओके इट इज रिक्वायर्ड, यू मे गो फॉर दैट. इफ द पर्सन अगेंस्ट होम अंडर सेक्शन 91 a summon is issued to produce a document or something etc, कोई डॉक्यूमेंट या कोई चीज आपने मंगवानी थी, इन्वेस्टिगेशन इंक्वायरी ट्रायल के दौरान उसकी जरूरत आपको लगती है, you may issue summons to such person, and if that person does not complies with the summon, you may issue search warrant. search warrant जारी किए जा सकते हैं. and who will be the authority for issuing such warrants? It is stated over here in section number 93 itself. In section number 93 itself, you people just see it is specified. कौन वारंट जारी करेगा? It is written na that nothing in this section shall authorize any magistrate other than district magistrate or chief judicial magistrate to grant a warrant for the search of a document, parcel or other thing in the custody of the postal or telegraph authority. अगर तो postal और telegraph authorities के पास से सर्च करवानी है तो केवल और केवल डीएम और सीजीएम के पास पावर है. बट विद रिस्पेक्ट टू द अदर थिंग्स या कहीं और से अगर आपको रिकवरी करवानी है तो और ये ऑर्डर सर्च वारंट्स जो है ये कौन जारी कर सकता है? Who will tell me? Yes, mention in the comment box what is there in section number 93 and who has the power to issue such warrants. Yes, अगर लिखा है तो बताओ. Yes, everyone. Is it written anywhere? Who will be issuing these warrants? Section number 93. I have to take a pause. I was continuously speaking from last 1 hour 45 minutes. Just tell me who will be issuing the search warrants. सर्च वारंट कौन जारी करेगा? Yes, everyone. Look, whenever the concerned document or thing, etc., is in the uh, custody of the telegraph authority or postal authorities, then it is very clear that district magistrate or chief judicial magistrate will be having the competency to pass orders for the search, and like search warrants can be issued. But with respect to the other things, if some at some other place the search is required to be done, then judicial magistrate first class is also having the competency to pass such orders if it is for the journal inspection or journal search is required. So let me tell you which point is relevant over here. You people just see in clause number C. In clause number C, it is written that where the court considers that the purpose of any inquiry or trial or other proceeding in this court will be served by a journal search or inspection, it may issue warrant. So court may issue warrant. It can be any court which is of the view that okay, search is required. It may issue warrant with respect to that. बट अगर टेलीग्राफ अथॉरिटीज के पास सर्च करवाना है तो हर कोर्ट के पास पावर नहीं है. किसके पास पावर है? ओनली टू द सीजेएम या फिर हमारे डिस्ट्रिक्ट मैजिस्ट्रेट के पास, जो डीसी साहब होते हैं उनके पास ये पावर रहती है. इसके साथ साथ आपका सेक्शन नंबर 94 आप देखें. 94 कह रहा है कि इफ अ पर्टिकुलर प्लेस विच इज सस्पेक्टेड एंड वेयर द स्टोलन प्रॉपर्टीज आर देयर, ऐसा कोई सस्पिशन है तो हु कैन इशू द सर्च वारंट? सो डीएम, एसडीएम एंड जीएम1सी, इनके पास पावर रहेगी वारंट्स को इशू करने की. ठीक है, तो बाकी इसमें आपको सिर्फ अथॉरिटीज का नाम ध्यान में रखना है, नथिंग एल्स अपार्ट फ्रॉम दैट इज रेलेवेंट. इसके बाद आपका सेक्शन नंबर 95 आप देखें, जस्ट टेक इट आउट. सेक्शन नंबर 95. सेक्शन 95 कहता है कि देखो कभी कभी क्या होता है, न्यूज़पेपर्स में कुछ एक पब्लिकेशंस आ जाती है जो कि ऑफेंसिव है. ठीक है, जैसे सेडिशियस मटेरियल को इसमें प्रिंट कर दिया गया है. सो इफ एनी न्यूज़पेपर और बुक और अ डॉक्यूमेंट विच इज प्रिंटेड एंड स्टेट गवर्नमेंट को ये लगता है इट कैरीज अ सेडिशियस मटेरियल विच इज इन वायलेशन ऑफ सेक्शन 124 कैपिटल ए, दैट इज सेडिशन, 153 कैपिटल ए, 153 बी, 292, 293, 295 कैपिटल ए, दैट इज ऑब्सीन एक्ट है या ऑब्सीन कोई उसमें चीजें हैं, सेडिशियस मटेरियल है, हार्मनी डिस्टर्ब करने वाली चीजें लिखी गई हैं, और गवर्नमेंट को अगर लगता है कि इस न्यूज़पेपर को फॉरफिट करना है, द गवर्नमेंट मे इशू दैट न्यूज़पेपर, बुक और डॉक्यूमेंट टू बी फॉरफिटेड टू द गवर्नमेंट. वो फॉरफिट हो सकती है चीजें. और अगर फॉरफिचर का ऑर्डर पास हुआ है, आप इस ऑर्डर को सेट असाइड करवाना चाहते हो, यू वांट टू गेट दिस ऑर्डर सेट असाइड, तो सेक्शन नंबर 96 कहता है दिस ऑर्डर कैन बी सेट असाइड बाय द, कौन करेगा? इट कैन बी सेट असाइड बाय द हाई कोर्ट विद इन how much time you have to make an application? That is within 2 months from the date of publication. You may apply to the high court to set aside the declaration. तो ये 2 महीने का समय जो है it's usually there in the multiple choice question कि कितने समय में हाई कोर्ट जो है इसको सेट असाइड करवाता है. इसके बाद नेक्स्ट आपके लिए जो रेलेवेंट सेक्शन रहेगा दैट इज सेक्शन नंबर 97. जस्ट टेक आउट सेक्शन नंबर 97. 97 resembles to the writ of habeas corpus. के लिख लेना बेयर एक्ट पे, कभी सवाल आ जाता है. 97 में क्या है? देखो हैबियस कॉर्पस में क्या होता है, इफ एनी पर्सन इज अनलॉफुली डिटेन्ड, इलीगली डिटेन्ड, उसको रिलीज करवाने के लिए आप रिट फाइल करते हैं हैबियस कॉर्पस का, और वहां से फिर रिट कोर्ट इशू करता है और रिलीज करने का ऑर्डर देता है. सिमिलरली इफ एनी पर्सन हु इज रॉन्गफुली कन्फाइंड एंड डिस्ट्रिक्ट मजिस्ट्रेट, सब डिविजनल मजिस्ट्रेट एंड मजिस्ट्रेट ऑफ फर्स्ट क्लास, इनको ये पता लगता है कि किसी व्यक्ति को अनलॉफुली या रॉन्गफुली कन्फाइन करके रखा गया था, then such magistrates like DM, SDM, ये दोनों आपके एग्जीक्यूटिव मैजिस्ट्रेट्स हैं. जुडिशरी की तरफ से जुडिशियल मैजिस्ट्रेट फर्स्ट क्लास इज हैविंग द पावर टू इशू सर्च वारंट विद रिस्पेक्ट टू सच पर्सन जिसको डिटेन किया गया, एंड दे कैन आल्सो इशू the orders for the release of such person with immediate effect. ये लिखा हुआ है that search shall be made in accordance therein and person if found shall be immediately taken before the magistrate. ठीक है, तो उसको इमीडिएटली आप मजिस्ट्रेट के सामने लेके आएंगे। सेक्शन नंबर 98 इज जो है ये एबडक्टेड फीमेल्स के लिए है। अगर कोई भी फीमेल जिसको एबडक्ट करके रखा गया है और फीमेल चाइल्ड अंडर द एज ऑफ 18 इयर्स अगर कोई है, तो डीएम, एसडीएम एंड मजिस्ट्रेट ऑफ फर्स्ट क्लास इज हैविंग द अथॉरिटी टू ऑर्डर द इमीडिएट रिस्टोरेशन ऑफ द वुमेन टू हर लिबर्टी। और किसको वो वुमेन सौंपी जाएगी? अगर फीमेल है या फीमेल चाइल्ड है तो शी विल बी हैंडेड ओवर टू हस्बैंड, पेरेंट, गार्जियन और एनी अदर पर्सन हैविंग द लॉफुल चार्ज ऑफ सच चाइल्ड। तो यहां से सवाल आते हैं। इसके बाद आपके लिए रेलेवेंट सेक्शन नंबर 100 है यहाँ पे, सेक्शन नंबर 100 कि अगर पुलिस अथॉरिटीज किसी क्लोज्ड प्लेस में सर्च कर रही है, इफ द पुलिस अथॉरिटीज आर सर्चिंग एट एनी क्लोज्ड प्लेस, मतलब किसी बंद जगह में जा रहे हैं, ड्वेलिंग हाउस में जा रहे हैं या किसी बिजनेस कॉर्पोरेशन के अंदर प्रीमाइसेस के अंदर जा रहे हैं, सो व्हाट विल बी द प्रोसेस? सो वेरेवर दे आर गोइंग, द पर्सन इन चार्ज ऑफ द क्लोज्ड प्लेस विल अलाउ the search of that place। हम मना नहीं कर सकते, provided the authorities should be having the competency to do that। उनके पास competency होनी चाहिए वो करने की। और अगर कोई भी व्यक्ति आपको सर्च करने से मना करता है, if any person without reasonable cause refuses or neglects or attends as a witness to such place, तो उसके अगेंस्ट 187 की प्रोसीडिंग्स आईपीसी के अंदर चल सकती है। देखो क्या होगा कि आप मान लीजिए पुलिस अथॉरिटीज किसी घर के अंदर तलाशी लेने गई, तो एक तो पहली चीज है कि आप उनको मना नहीं कर सकते। इफ दे हैव द सर्च वारंट, दे विल शो यू द सर्च वारंट एंड यू विल हैव टू अलाउ सच पर्संस टू हैव द सर्च ऑफ द क्लोज्ड प्रीमाइसेस। नंबर 2, नाउ from the neighborhood the police authorities will be asking that okay, you will be a witness of this particular search, and if someone without any reason refuses to be a witness, then against such person under section 187 of the IPC proceedings can be taken up। ठीक है, तो इसका आपको ध्यान रखना है। सेक्शन 187 का सेक्शन 100 के साथ एक कनेक्शन है कि जब भी पुलिस अथॉरिटीज किसी जगह पे सर्च करने जाती हैं, वारंट दिखाती है वहां पे कि हम सर्च करने आए हैं, और व्यक्ति अगर मना करे तो वो ऑब्स्ट्रक्ट कर रहा है, वो 186 के अंदर अपराध हो जाएगा। और अगर किसी व्यक्ति को कहा गया कि आपको विटनेस बनना है इस पूरी सर्च का, और वो व्यक्ति अगर मना करे विदाउट एनी रीजन, तो इट इज एन ऑफेंस अंडर सेक्शन नंबर 187 ऑफ द आईपीसी। लास्ट प्रोविजन इन द टुडेस सेशन व्हिच वी आर हैविंग नाउ, दैट इज सेक्शन नंबर 103 एंड 104। यहां से सवाल काफी बार पूछे जाते हैं, डायरेक्ट हेडिंग्स पूछी जाती है, नथिंग बियॉन्ड दैट। यू पीपल मस्ट हैव टू अंडरस्टैंड व्हाट इज द बेयर हेडिंग। 103 कि अगर मजिस्ट्रेट कहीं पे अगर मौजूद हैं और उनको लगता है कि सर्च ऑर्डर देना है, ही इज कॉम्पिटेंट एनफ टू इशू द सर्च ऑर्डर डायरेक्टली। एनी मजिस्ट्रेट मे डायरेक्ट अ सर्च टू बी मेड इन हिज प्रेजेंस of any place of which he is competent to issue the search warrant। क्योंकि अगर वारंट नहीं है लेकिन मजिस्ट्रेट साहब खुद बैठे हैं, तो मजिस्ट्रेट साहब कैन डायरेक्ट द सर्च ऑफ सच पर्टिकुलर प्लेस इन हिज प्रेजेंस इटसेल्फ, जिसका अभी उन्होंने वारंट भी जारी नहीं किया था। और 104 जो है, इट एम्पावर्स द कोर्ट टू इम्पाउंड एनी डॉक्यूमेंट और अ थिंग बिफोर इट अंडर दिस कोड। कोई भी चीज अगर कोर्ट के सामने पेश की जाती है, रखी जाती है, मैजिस्ट्रेट इज ऑफ द व्यू दैट दिस थिंग इज रिक्वायर्ड टू बी इम्पाउंडेड, मैजिस्ट्रेट हैज द कॉम्पिटेंसी अंडर सेक्शन 104 ऑफ द सीआरपीसी टू गो फॉर द इम्पाउंडिंग। सो बाय दिस वी हैव डन टिल सेक्शन 100। ठीक है, वी हैड डन अ वेरी क्विक एंड फास्ट रैपिड रिवीजन टिल सेक्शन 100। अभी इसके बाद जो हमारा नेक्स्ट एरिया है, दैट विल बी टेकिंग अप बाय द टुमारो सेशन। ठीक है, जिसमें हमारा एफआईआर एंड द अदर एरियाज विल बी देयर। अभी जितना सेक्शन 100 में व्हाटएवर आई हैव टेल यू टोल्ड यू पीपल दैट दीज आर द इंपॉर्टेंट सेक्शंस, इनको बेरेक में अच्छे से पढ़ जाओ। ठीक है, लीव नथिंग, कुछ भी छोड़ना नहीं। अगर कुछ भी छोड़ के जाओगे तो फिर अच्छे से तैयारी नहीं हो पाएगी। तो डीजीएस की जहां तक बात है, बेरेक इज अ की टू सक्सेस विद रिस्पेक्ट टू टेलीजुडिशियल। Okay, so you people must be very much clear on this particular point that yes, this is the thing that we have to do. Chaliye, so we are done with the session. Thank you so much. Now we will be meeting on some other session with respect to the upcoming provisions of the CRPC. Thank you so much. Bye. Take care.